I'm not sure I can hear anything. Can you say something? Can you hear me?
Yeah.
Oh, actually, I can lip read you. That's quite clever.
Hello, everybody. Welcome to this week's Legal Hour with Court Wingman. We are here today with our leading solicitor, Alex Woods, who will hopefully be able to answer any of your burning questions about civil litigation and suing people. So if you do have a question for Alex, do comment right now with your question and he will answer them for you. Alex, I see you still have your wacky broken glasses.
Yeah, I just have to look that way and then I'm all right.
No, it really doesn't work.
Well, you try finding an optician who's actually competent enough in Warsaw to fix them. I've been all over the place, but these are perfect glasses. I'm just trying to find someone who can actually, well, look, you guys out there, you could help me, yeah, rather than me giving all the free help and advice. Can someone recommend how I attach, fix my glasses? Because there must be some way of grinding it down, putting some super glue in or a pin. But the opticians just go, oh no, just go to another shop somewhere else, and I never get anywhere. So I'm a bit annoyed. I've got two of these pairs of glasses, and now both of them are broken. I got them in the UK, so ho hum. Any comments on how to fix my glasses?
None yet.
Really?
Yeah.
Okay.
There's no questions either, which is a surprise. So we definitely have two people watching, but maybe they're a bit too shy to leave a comment.
Interesting. I think we do need one of those two people, both of them, to wade in there and tell me what their issue is, and so that we can steer the legal surgery in the right direction. Or they can email you, can't they?
Yeah,
can they email at hello@courtwingman.com?
That is correct. Well,
I mean, we usually charge 150 quid an hour plus VAT. You've got so two of you, 3 hour, you could get absolutely £180 worth of legal surgery today.
They could. Well, we'll give everyone a few minutes.
How did we do from last week? Is there any follow-up?
So we had a lot of playbacks from last week. So what we have introduced as an add-on, which was a suggestion from one of our subscribers, was to add tags. So last week I went over the video and tagged the timing of when the question is asked. So if anyone is on the channel and they go on that video, in the description they can see what questions were asked and just jump right into that question. Yeah,
I noticed that. I thought that was really good.
I mean, it took some time, but it did get us a lot of people watching. So we have about 130 people who watched the repeat after we hosted it. Okay, well, let's use the time, split it in two.
First half, strikeout applications. It's a recurring issue, and I've got a case this week that I've been advising on, and he suggested we do a video on it. So let's talk about that. It's a low value claim. There's no real confidentiality issue here. But then I would also, in the second half, like to talk about the problem of lawyers. We've had what I consider to be a horrific case come in recently, a property cohabitation type will case where a lovely grandmother has left a lot of assets to her grandchildren, and they've done the dirty on her. That's a soap opera in itself. Well, one of them has. I mean, stay tuned. And I'm going to unashamedly talk about it because I think because you'd want me to. I'm not going to mention names, obviously, but it is such a good example of a really high value claim and the problems of actually suing defendants and actually getting them to take notice. And also the problem with lawyers, because she's been round the houses, spent, £15,000 or whatever it is, over 5 years, going absolutely nowhere, and then not issuing. I'll probably get in trouble with someone for well, I've not mentioned any names, but I'm not impressed by a lot of lawyers who just take the money and just write long letters and say, we're going to issue if you don't reply, and make offers that get rejected, and never actually pull the trigger and issue proceedings. So that's part two.
That's how they make money. So
well, that I'm going to look into the issues. I'm going to lift the lid on the way the legal profession works. So stay tuned.
Well,
now you can pretend to be a litigant in person with a claim, and you're faced, cook up a little story, and you're faced with a strikeout application. Actually, I'll give you the bare bones, and then you can kind of say, what do I do? So let's take this as a hypothetical example, but based on a real life case. So let's say you are a builder. You work for another builder to help him on his jobs from time to time, and he hasn't settled a few grand's worth of invoices. Okay, it's a small claim. He doesn't. You chase him. You instruct debt collectors. You spend time and money, and he cooks up first an excuse about the amounts and of the invoices, which isn't really credible. Then and then he starts to blather on in correspondence. He ignores it until he gets a letter from the debt collector, and then he comes up with an excuse. Anyway, and the excuse is, let's manufacture an excuse. An excuse is, oh, I know what the excuse is. I helped this guy with his jobs a couple of years ago. Yeah. So, he was refitting his house, and I did a lot of work for him. So I'm not paying these invoices 2 years later because of the work that I did 2 years ago. And actually, he was doing the work back 2 years ago when they first met, and he was just doing it as a friendly favor. But now he's trying to wriggle out of paying 3 grand's worth of invoices. So he's cooked up this, he's dragged this, there'll be something. A determined defendant will find some nonsense from the past. Anyway, so you issue proceedings. That's the only excuse he's come up with. You're then met with the defense. Here's the interesting part, and a counterclaim. A defense saying that you're not paying the invoices, and this is real life situation, because when you were working for me, the defendant, you used my account, my building account, to get materials from the wholesalers and tools, which you then kept. And actually, you've got a big counterclaim. I've got a counterclaim against you for return of tools and materials. And the guy he didn't even say that much in his defense. It was like one sentence, that kind of tools and materials that hasn't been paid for, and he's kept them. Yeah.
Why have I kept them?
Sorry?
Why have I kept the materials and tools?
Yeah. Well, you're jumping to the conclusion that there's some natural truth in what I've just said. Because what you'll discover is defendants will cook things up. A defendant is defending proceedings for one of two reasons. Either he's got a genuine defense, or he hasn't got the money.
Why would you go to such lengths to create a lie like that and submit it to court?
Well, it's kind of got a plausibility about it, because our client is the claimant. He did work for this guy on a number of different jobs for him. Yeah. His properties, yeah. And he did go to the wholesalers to buy materials, and he used the defendant's, building account with that building wholesalers to buy materials and tools.
But surely that was authorized, was it not?
Well, yeah. So that exactly. So you can tell he actually asked for an extension. When you file a defense, just to deal with detail quickly, when you get a claim, you look at the issue. If you're a defendant, you look at the issue date. You've probably had 2 days for service, it actually arriving on your front doormat or your computer. And then you have a clock. You've got to
Yeah.
respond with a defence in 14 days. But if you file an acknowledgement of service in 14 days, you can do the defence in 28 days from the date of issue. So if you file within 14 days, you file an acknowledgement of service, you get an extra 2 weeks. So you've got a month basically. If you file an acknowledgement of service, if you don't, you've only got 2 weeks. So this guy actually did get an extension. Even after a month, the best he could come up with was basically 2 lines, but a counterclaim as well. So he's kind of trying to turn the tables. So yeah, what was your question again?
Oh, I forgot now what my question was.
I
My
think it was
next
something-
question was, what's an acknowledgement of service and how do you provide it?
Yeah, so when you get a claim sent to you by the court, you have to respond. And there's a pack you have to fill in. And there's a box that says, do you intend to defend? Do you intend to admit liability? Do you intend to admit complete liability? And then it goes on to explain, you have 14 days within which to file a defence. But if you file an acknowledgement of service, you've got an extra 14 days. Well, you've got 28 days from the date of service of the claim rather than 14. So that's all an acknowledgement of service is the fancy legal word for your opponent receiving the claim from you. You serve a claim on your opponent, you file a claim with the court. So file means court, you're filing with the court papers. Service means you're kind of, I guess it goes back to olden days when you actually turned up in front of somebody and served them on a plate. This is the claim, I'm going to sue you. And you have to do it in person, you know, all that.
Kind of like they do it on movies. In movies, that's what they do.
Like they do in movies with process servers, they're called. So anyway, that's the claim. But remember, we need to keep focused on strikeout because the question is, it's a tissue of lies. He's only, I say it's a tissue of lies. It's plausible, but not really a defence. He came up with another story in respect to the debt collector, saying he'd done a job for the claimant 2 years ago. He should be paid for it now. Then he's changed his tune in the actual defence is submitted, and it's very thin. It's only 1 line. I mean, literally 18 words max, his entire defence. And his counterclaim is about 10 words. You know, I'm counterclaiming for the tools and materials that were taken by the claimant. I wasn't given the money for. You know, the ones that he used my account to pay for, and they haven't been returned. So what does a claimant do in that situation?
Yeah, what do I do? You need to tell me what to do.
All right, so got any guesses? Go on.
What do I have to do?
You studied at law school, didn't you?
I did, although nothing about building disputes. But surely it's, I just need to collect my evidence and be like, actually, here's a WhatsApp conversation between me and him where I asked whether he's sure that I need to go to the shop and get those specific materials and screenshot that, attach it to all the other documents that prove the value of my claim and just submit it to the court. And surely his actions with the evidence that I supply in a chronological order will do its job with a judge.
Yeah, I mean, that's quite a useful response. It's a common sense sort of response. But actually, when you issue proceedings, as per my book, I found a way to segue into a book plug.
Here it is.
When you issue proceedings, yeah, you're no longer just 2 bods having an argument in the car park. You're now a pilot in a cockpit of an aeroplane with all sorts of rules, procedures and protocols, air traffic corridors and runways and so on.
And strategies.
Well, yeah, strategies also, absolutely. But the point is, the dilemma you're facing is that you're now in a rarefied atmosphere of the litigation system governed by the civil procedure rules.
Indeed.
Now, what you've said is fine, but how do you go actually physically about, remedying the problem and dealing with the tissue-thin defence and counterclaim?
Can I pause you for a little bit? We have had a question in relation to the builder's case, actually, which is explaining a Part 20 application. Is it an option in the builder's case?
Well, a Part 20 application is usually you're joining another party to the proceedings, like a second defendant.
So when would you deploy that strategy?
I don't quite see how it relates in the context. Let's have a look at that particular CPR rule. Maybe there's a bit of it that I've misunderstood. I'm afraid to say.
I'm just reading you questions. And another.
Well, let's have a look, because CPR Part 20 does come up sometimes. I mean, I guess that she's talking about the counterclaim.
The follow-up question is: can a judge sit on two different cases with the same party? That's another question from the same person.
Don't know.
I
would think a judge would probably avoid that. Absolutely, because if you go, just think about it logically, if it goes to trial and he has to make a decision about the honesty of that person, and he finds that person's been dishonest, he's not going to be handling a case with the same person. So he would foresee that possible conflict early on and make sure it got farmed. So no, the answer is he wouldn't handle two completely different claims with the same claimant or defendant.
Oh, what if they don't realise that? Let's say they do it not with malice.
Well, I think we're getting to the realms of hypothetical, and it's not really very practical and useful for the majority of listeners out there. Yeah. So let's go back, unless our viewers got more probing questions in relation to this issue of application, because I try and make this practical, not theoretical. This isn't for law students. This is for people who've got claims. So
the follow-up question, why I've asked that is because another follow-up question is: do I make an application to the court for the judge to recruit herself?
I've missed that last couple of words. Recruits herself.
Yeah, as in retire from that case, I suppose.
Let's get back to strikeout applications, okay? I've never ever come across that issue. It sounds hypothetical, and like a professor of law might have the answer to that, but it never comes up in litigation in my life. Because don't forget, there'll be not just people who are listening now, people who will listen to this later on. So it would be good to pack them a punch with this half an hour on strikeout. So the question is, how are you going to deal with this? This is quite a tricky question. Can you think of various different ways you might respond?
Mm-hmm.
You would think you haven't read the book.
Oh,
you're in danger of getting a legal lesson from me now. But
well, you are the lawyer in this scenario. Sorry, my brain is a bit fried today.
Right, and you're playing your role. You're playing your role perfectly by pretending not to know when you really do. So great. So continue to role play. But if you get a defence and a counterclaim, what do you do? What are your options as a claimant?
As a claimant?
Yeah. You filed particulars of claim. The defendant has now filed defence and a counterclaim, and it's very paper thin. And yes, as in your example, there's a text message which says, "Sorry, mate, I can't pay you right now. I haven't got the money." So it's a weak defence and counterclaim. You know it, but he's playing the court system and kind of calling your bluff, and
Okay. Well, since I've listened to some of your YouTube videos, in this scenario, I'd probably think about 3 things. One, just respond to the defense and be like, oh, this is complete and utter nonsense, and then strike out the counterclaim. Or try and push this out. Well, no, that wouldn't work. It's only £3,000. Never mind, I was thinking out loud with tracks, etc.
Well, let's just keep it super simple. When you get a defence and counterclaim, you have the option to file a reply to their defence as a claimant. Then that then closes the statements of case phase, particulars of claim, defence, reply to defence. Reply doesn't need to be very long and isn't necessary, but sometimes people use it. But don't forget that the counterclaim is just like a claim. So as well as a reply, you put in a defence to the counterclaim. So you're now putting in defence to the counterclaim. That's the simplest response to defence and counterclaim if you are a claimant. But what happens when you're presented with a really weak-looking case like this? Do you just follow the usual protocol, or are there other avenues available to you?
Well, there must be other ones available.
Well, you've mentioned it. I'm teasing.
This one's a waste of time responding in a proper way.
Exactly. What's a technical word for a waste of time in legal parlance?
I don't know. This is my first claim.
Abusive process, for example. So you start to think this is an abusive process because I actually think he's using the court system to avoid paying a debt. We're now in, and those about you, the geeks, you know what? You don't need lawyers. You can do this all yourself on your laptop. Go into justice.gov.uk. Okay. This is golden free advice. I'll tell you what. I don't know why I do these free videos. Just to be nice. CPR, Strikeout. And I did this week with a guy. I charged him 2 hours of work and I helped him to draft up his own strikeout application in a case very similar to the one I've just outlined.
Well, you make it sound like this 2 hours of work is actually very easy work. But you only say that because you're over-assuming how much knowledge goes into drafting.
No, the 2 hours was just me reviewing his work. He had to do a lot of work himself, preparing it. I then gave him the advice of what to do tactically, told him he should strike out, blah, blah, blah. He then went away and drafted an application to strike out, and then I checked it. So
since it was a one-line defence, how many pages was the strikeout application?
Let's just take this one step at a time. Sorry, I'm just trying to keep it on track. So if you're, where you've got a situation where there's, some abuse. Now the question is, what are the criteria you need to meet in order to be successful in the strikeout application? Okay, we'll go into the civil procedure rules and have a look. And you'll find there are various criteria. Perhaps you can So CPR 3.4, power to strike out a statement of case. The court can actually strike out a statement of case of its own volition without an application being made, which does sometimes happen where litigants in person are concerned. Here are the sort of criteria. There are 3 given here. Failure to disclose reasonable grounds bringing or defending the claim, abuse of the court's process, failure to comply with the rule, practice, direction, or court order. So we start, if we apply that criteria to our case, then there are probably no reason. I'm just going to move to make sure that I don't lose charge. So you've got to apply those 3 criteria. And you start to think, yeah, it's a bit of an abuse of the court's process. Yeah, there is no reasonable grounds for defending this claim. It's just a debt recovery matter and he's trying to avoid the debt by playing the court system. Yeah. Suddenly you start, and yeah, maybe he probably hasn't failed to comply with the court order. He's not been late with his defence. Or has he? Actually, he has failed to comply with the court order and rules of court because he hasn't filed a defence. His 18 words is no defence at all. His counterclaim is also woefully inadequate because it doesn't particularise his losses. What about these tools and these materials that apparently he bought on his account? He doesn't even list them. He certainly doesn't give the value of them. He just bungs in a figure, the 3,000 in the counterclaim. So you can start to see how, when you drill into it and apply those rules, you can make an application to strike out an opponent's claim. Now, this can be a very strong weapon. And why, Kinga?
Why?
Why can it be a strong weapon?
I am just a builder. I do not.
Okay, it's on the small claims track. Why is it? But no, it's it's a small claim, but it's not been allocated yet. So what people don't realise is that even though you've got a small claim, until it's actually allocated to a track, the small claims track, it's like any other claim. So if you bring a strikeout application and you win it, your opponent has to pay your costs. Let's say you send, just for that strikeout hearing, you send a barrister $2,000, or you've got costs, travel expenses, a half day off work, you've taken some legal advice from courtwingman.com. You then get your costs if you win, because it hasn't been allocated to the small claims track yet. And this is a big issue for a lot of people. They don't realize, particularly the big banks or big corporations play this game. If a litigant in person fails to properly lay out whether it's a claim or their claim, they will often, sometimes before even filing a defence, make an application to strike out, because they're getting it a blow in early, and they're intimidating the opponent because they'll send expensive lawyers to a 2-hour hearing, and suddenly they could end up well out of money when they thought it was just a small claim, but it's not until it's allocated. Read the book. Where's the book? You can probably find there's a chapter in there called Misconceptions, isn't there?
There is. Let me just tell you which chapter it is.
So I'll just waffle on whilst you're finding that chapter. So the next question is, well, how do you bring this application? And the answer is you use our good old friend, the N244 guidance in the book about how to complete the N244. You need to pay a court fee. It's £255 at the moment. And you need to include evidence. So you actually need to include kind of a witness statement as best you can. And critically, you need to include the correspondence. Now, this comes back to your earlier point, Kinga. There's a text message that says, sorry, mate, I haven't got the money. That is evidence that goes into your strikeout application under cover of a witness statement. It can just be one little page that says, please find attached a 10-page bundle of correspondence which shows this defence and counterclaim is total nonsense. Also, with this, in this bit, each claim differs, but in the claim I've just been dealing with, I've actually advised him also to file a reply and a defence to the counterclaim, even though one's hardly needed because his defence and counterclaim is inadequately particularised. Just to be on the safe side, I've submitted it so a judge can see he's been a good boy and he has filed a reply and a defence to the counterclaim. But I've made it very short, not verbose, quite short, because you don't want to give a dodgy defendant more ammunition to cook up errors and lies and things. So his response is, no, the tools and materials that I used on his account at the building wholesalers were disposable tools and materials for the jobs that I was doing in his properties. Tape for the carpets or underlay or special tools you use for laying carpets or whatever it might be. they weren't like a drill or a sander worth £500. So we've kept it short. We've just said that. We haven't gone into more detail in the defence to the counterclaim in this instance, and we've kept the reply to the defence short as well. So you can see how with that N244, a witness statement with the evidence and with your own reply and defence to counterclaim, covering letter with the court fee, sent to the court, your opponent is then going to get a court order down the track saying this matter has been listed for a strikeout application of 1 hour, 2 hours in length in front of the judge at the County Court of X. That can be quite a powerful way of putting in a right hook for a defendant who's just playing the court system. But only do it if you really do think that they are just in the category of trying to avoid debts. So often people have a rose-tinted view of their case and fantasize that they're all right and their opponent's wrong. Most cases, it's half a dozen of one and 6 of another.
Okay, well, to conclude this chapter, the small claims, a common misconception bit is actually provided in our free sample of the book worth $7.99, which you can download at book.courtwingman.com. So that's book.courtwingman.com, and you can download essentially the information Alex just talked about, minus the particular strategy which is explained later on in the book.
Yeah, because we do lay out an N244 and show you how to put it.
Yeah.
You have been plugged.
We've got a question here. It's from a travel agent. So after serving court notice along the way to court, your opponent pays up. What do you do? And can I recover my legal costs?
Yeah, if you've issued a claim and that has triggered, as often as it does, the defendant into coughing up, then you say, thank you very much. Here's my lawyer's cost bill. Play that as well, please.
So it's just been, so I don't know whether it's just been served, but yeah, it has, after serving court notice along the way to court. Your opponent.
I don't know what he means by that. I mean, walking to court. Obviously, I'm talking about a situation where a claim has been issued by the court, a stamp with a date on it, and then the defendant is settled after that. In those circumstances, you write him a stiff letter saying, thank you very much, and here's my cost bill, 14 days, please. Check or bank transfer, here are my account details. And if they then ignore you, you go, the claim's still issued. They haven't finished the proceedings. You just wait for the first hearing and you produce your cost bill in front of a judge. And then your cost bill by that point is even bigger.
Huh. Well, in this scenario, I suppose, even after the opponent pays up, like if they already paid you, how would you get them to pay at a hearing? Would you then just recover your legal costs?
Yeah, the hearing will just be to deal with your costs.
Okay, that makes perfect sense. And to add, this travel agent...
Without going into technicalities, there are qualifications to what I've said, but that's tailored legal advice territory. But generally, that's what you do. You see, once proceedings are issued, it's quite powerful because then the opponents can't wriggle out of those proceedings without having cost consequences. So let's say a claimant settled after they'd issued because they realised actually the defence is quite strong. They'd then have to pay the defendant's costs of discontinuing their claim.
Okay, well, that makes sense. To add to this one, the travel agent has already been taken to court by other customers and had judgments made on them.
Yeah, irrelevant. Never talk about other dirty laundry in your opponent's life. Yeah, judges are not interested. I've seen that this week in the claim. Oh, but the defendant was this happened before and he was roasted. The judge said, "You're a liar and a thief. You know, can I put it in my claim?" No.
No, you cannot.
Judge is not interested. he will actually become suspicious of you if you're a mudslinger. Don't mudsling. Be surgical, be legal, be clinical, be ruthless, but don't get emotional and start slinging mud around. Focus on the issues, not what relevance is some. Everyone's got skeletons in the cupboards. He beat my brother up when he was a kid. So can you give me judgment? Well, no. What relevance is that to the issue of having wrongly fit your carpets or having not paid out an invoice, for labouring work? It ain't relevant, my friend. Even if he's being convicted and sent to prison, the judge isn't interested in the county court proceedings. For defrauding people of, it's not a criminal matter, it's a civil matter, and the judge will be focused on the facts of that individual dispute first and foremost. If it comes to trial and there's an issue around the honesty of a party, there may be opportunity to bring in a bit of the past. But you probably only ever do that quite late in proceedings, like a witness statement stage. Okay. But I hesitate to say that because people will take that the wrong way.
Okay. Another one is from an ex-client of yours from 2 years ago. They were at the High Court, and their question is going back to this because we kind of covered it, but it was mid scenario. Is that they have a case with a judge, well, two different cases that are not related with the same judge. It is a real scenario. And they had 20 proceedings in front of a High Court judge. The other party has not succeeded in the strikeout application. What do they do?
That's a tailored legal advice question. Send in an email to hello@courtwingman.com. Yeah. And I think we should stick to the program. We're going to move on from strikeout applications. Apologies to the questioner, but we're past the half-hour mark, and this issue of having a judge handling more than one claim for the same person is very esoteric. Even I don't know what the answer is, frankly. Just my hunch, the judge wouldn't do that typically, normally. Perhaps you've got an exception, but it's starting to look like a very fact-specific case that we could spend the next 20 minutes going around in circles talking about. So, sorry. I think we should move on.
The email is hello@courtwingman.com if you do want to send an inquiry and attach your paperwork, etc. Another question is, do they take your personal injury monies in divorce and not freeze the defendant's assets?
Don't know anything about divorce law, I'm afraid.
That's a question for Daria.
Yeah, she's not here at the moment. I'm in Belarus, in Minsk, and she's not come with me for obvious reasons. But you're quite right. Sorry, we do have a family solicitor, and I'm sure if you email, she'd be happy to take a look at your case.
Definitely.
But I'm afraid I've never dealt with a divorce in my life. I've dealt with a lot of cohabitation, property disputes, and child maintenance issues. But actually, people often don't realise cohabitation disputes are, quite different from going through a divorce.
They are indeed.
Sorry, not really help.
Well, I suppose it's okay. We can't know everything.
It's not a county court matter, divorce. It's the special family courts that deal with divorces.
I'm afraid I have run out of live questions. If anyone does have a question for Alex, do type away. Please do keep it quite generic. Otherwise, he will not be able to answer, because the most famous lawyer answer is, it depends.
Yeah, exactly. But I mean, if someone had emailed in with a little example like we've just given, I've sued a builder and he's come up with a one-line defense, and it's the first time he's come up with a defense. Do I file my reply and defense to his counterclaim? then that's an excellent question, because we can then talk through the specific question about the general issue of strikeout applications or summary judgments or judgment in default for that matter. Not time to talk about those things today. So I just wanted to just talk about the problem of lawyers. And I think you rather nicely put your finger on it, Kinga, by saying that it must be one of the few professions where you are literally incentivized to have your client go around in circles. Mm-hmm. It's shocking, isn't it, when you think to admit it? And I guess that's why perhaps it is important to have a regulator and a law society and a complaints procedure. Because when you think about it, lawyers like sitting at their desks writing letters, making the occasional phone call. Gross generalization, but a lot of sort of truth in it. Taking your instructions, drafting documents. But when it comes to but they're conservative animals, lawyers. So when it comes to, let's take the case of this grandmother who has made disposition. She made a will, and then she wanted to benefit her grandchildren during her lifetime. Mm-hmm. And so she gave one of them the family home. Well, that was the intention. And another one, a house of her own to get her on the property ladder. And she made the mistake of having the scheming granddaughter, whom she trusted, putting her on the title deeds of the family home so that she could release equity, because the grandmother was too old to get a mortgage, to get equity out so that, to make this whole arrangement work. Because obviously mortgage companies have strict requirements and so on and so forth. So now what's its complex claim, high value claim, £500,000 type claim. And what's happened is her plans, the generosity of her soul to benefit her two grandchildren, have been derailed in quite a appalling way, in my view. I've never seen a case like it, by a granddaughter who's just milked her grandma of money and is now actually trying to get hold of the family home, because she was put on the title deeds in order that it could be she could raise refinancing to buy her own home. And she's merciless, and she's squashing her brother, the grandson, and trying to get him to come off the deeds, because he was put on the deeds as well, because he's meant to inherit that house, the old family home. It's the granddaughter who's meant to go and use the refinancing to find her own house, which she has found, she's got, but she still wants more. She wants the family jewelry.
Wow, that is really cheeky.
Having got the money to, this has gone on for 10 years nearly, this whole dispute, and the lawyers have been involved for 5. Having got the money, having the grandmother, having put her on the title deeds of the family home so that money could be taken out, had her own house bought for her. She's even misappropriated some of the funds that have been refinanced from remortgaging for her own uses. And she's now, as if that's not enough, she now wants the family home as well, and to kick her brother out who was meant to inherit it.
That's something else.
Now, I've got a prejudicial view. You often do get too close to your client's cases. But I can't see where the defense in this claim is coming from, but we're yet to issue proceedings. Now, here's the point. You got a really strong, certainly a very morally strong, not entirely, it's not 100% slam dunk in terms of the legals, because there wasn't a specific trustee drawn up at the time these dispositions were made by lawyers, which would have helped. It was all done, by word of mouth and family loyalty and family trust. But But here's the thing, it's really, as you can imagine, it's quite a complicated case. And she's managed to spend 5 figures on lawyers over the past 5 years, the same lawyer, the same law firm. According to the client, there's no reason to distrust her. I haven't seen the actual bill, but I think it's definitely around, quite a lot of money. But the point is, without those lawyers ever having issued proceedings.
That's quite disgraceful, to be fair.
Well, it does sound disgraceful, but if those lawyers are in the room, perhaps they might say, well, the client and this is the issue of the day, really. The lawyers are incentivized to try and settle without going to court, because Lord Justice Wolfe, back in the day when he created the civil procedure rules, was all about everyone's got to try and resolve their disputes with arbitration or mediation or whatever before issuing. So lawyers are now terrified of going to court and wrongly advising their client to go to court without having exhausted pre-issue negotiations and mediation, alternative dispute resolution, it's called, chapter in the book or section in the book. So that's one thing. Often people don't want to, particularly the family, you don't want to issue proceedings, sue, marry your own family. So you're always trying to look for other ways of coming to accommodation. But in this case, which is an example of many other cases, all that's doing is ringing up the legal bill more and more and more, because ultimately, if someone doesn't want to play ball, they're just going to go, go on, sue me. You haven't got big enough balls. And that's basically the way that a lot of defendants operate. And unfortunately, there are problems because the court fees have gone up hugely over the last few years. They're now 5% of the claim value in monetary claims. So for 150 grand, but I think there's a ceiling of 10 grand, but for 150 grand claim or 500 grand claim, and it's property. It's not like you've got the money. You may be property rich, but not cash rich. You've just to issue the claim in order to get your opponent to sit up and take this seriously. You've got to find 5% of the value of your claim. And if it's 150,000, what's that? What's 5% of 150,000? 7.5 grand, isn't it?
Around that, yeah.
Just to get the thing issued at court. Plus, you've got to pay the barristers to draft the particulars and the lawyers to do this and that and the other. So you can see why. I bet this happens in a huge amount, that law firms go round in circles with correspondence because they all know the game. And their clients are nervous about spending 10,000, so they're forever trying to settle out of court. And maybe this is the problem now, that maybe it's not the law firm's fault. Maybe it's the client who's nervous about finding those fees.
Possibly. Well, I've got another 2.
Even so, you would think best practice would be for a law firm to say, right, look, either walk away and just go on with your life, or you've got to find the money, rather than continually trying to settle through mediation and negotiation and long letters and barristers' advices. You've got to issue sometimes. Sometimes you've got to bite the bullet and issue. And actually, you can sometimes find no-win, no-fee lawyers, but that doesn't deal with the issue fee. But I've just today had a conversation with the after the event insurer who thinks he can find the money to pay the court fee to fund your expenses. Obviously, they'll want a share of your winnings, but there are ways now for more experienced lawyers to access insurance to help you fund the disbursement in a really strong case for the issue fee.
Well, you do that, don't you? There's a separate video on the channel about that where you use the pirate analogy.
Yeah, the no-win, no-fee. I mean, if you have got a high-value case, property dispute or contested will is what we tend to specialise in. But any dispute, people don't realise that no win, no fee can be used for cases other than personal injury. In the personal injury sector, it's the only thing that's often used is no win, no fee retainers. But people don't realise that you can use contingency arrangements, no win, no fee is a common one, to get a lawyer to work for free, in inverted commas, and they don't get paid if they don't win. And there's a big chapter in the book about it. So let's plug the book.
On that note, I've got 3 questions for you. So
excellent.
Have to do.
People must be getting bored of me whittering on.
Well, I'm sure someone will watch this and find it very useful when they come back to it, except for a few people are watching right now that are waiting for their answers. But that's part of the deal, I'm afraid. That's why we have personal one-to-ones where you sit down with a lawyer and discuss your case. So I'm sorry. But anyway, next question is, can I claim emotional distress and legal costs at court? So
good question. We've done a vlog on that, actually. The general rule is no. Unless, but the exception is where it accompanies an otherwise normal claim for damages. So if you're to take personal injury and you've broken your arm in a car accident, you claim for £10,000 or whatever it is. But let's say it's caused a lot of sleepless nights and visits to doctors and mental breakdowns and loss of your job, you can then claim that on top. But if you didn't break your arm and you only had emotional distress, it's very difficult to bring a claim like that through the courts. The courts tend not, because if they started to allow emotional distress claims as a standalone claim, it would open the floodgates to anybody who'd ever had their feelings hurt. So no, you usually need to run it alongside an existing traditional claim for loss of money or personal injury. I'm not going to get into just one final. No, I'm not going to get into employment law. Obviously, the employment cases are concerned. You are claiming for emotional distress, but that's a specific in a specific area. There might be a clause in the contract that says if the contract is breached and you're caused unhappiness or loss of peace of life, right to lead a quiet life, let's say, it was specifically spelled out in a contract, and then you could have a simple breach of contract claim. But generally, emotional distress claims aren't standalone actions in English law.
We actually did cover this on the last lawyer question and answer session. And if you go back to that video, they will, in the description, you'll find the timestamp of when we discussed that issue. So do go back to it because we've discussed it there too, and you might find some value there. Another question is how well the court.
They also asked about legal costs, Kinga, or do we need to answer that part?
So the second question kind of relates to this one too. So can I claim legal costs? Obviously, yes. Obviously,
absolutely. If you're in court and you're the winner, you claim for your legal costs. Well, not just legal, and any costs associated with bringing the claim.
Does that relate to the small claims track too? If your case
well, in the small claims track, you can get experts' fees. You can't get your legal fees paid if you win, but you can get an expert's fees paid, I think to a maximum of £750. And you get your court fees back if you win.
What's covered under expert fees?
Well, let's say you got a building dispute and you get an expert in to say, yeah, he put the wall up wrong, and that's what caused the damage to the floor. And you instruct an expert jointly in a small claim, and you will get the court. If you win, the court will give you back whatever you paid to get that expert to do that report. So that's an exception to the rule, the rule that you don't get your costs in the small claims court. You don't get your legal costs in the small claims court if you win.
On that note, how does a court recover recover money from a defendant, let's say a travel agent, and can the claimant recommend how the court is to recover those funds, i.e. from an account, a specific account, especially if you're worried about their honesty? Or
there isn't really time to go into this. There is a section in the book on enforcement. I did a video on this for free on the YouTube channel about enforcement proceedings.
Let me just get the chapter.
It might be a little out of date, but really enforcement proceedings are, you've got sort of different options, attaching it to their salary or their bank account, or you've got different ways of trying to enforce a judgment, ultimately instructing bailiffs, usually, but I think perhaps the most useful thing, because things rarely get that far, is that I think the most useful comment in the time available is just to say that after you get judgment for like £10,000, and then you try, the court says the opponent has to pay within 14 days, and they don't, and then you've got to go back to court. The court will often send out a sort of financial means form, and you'll find yourself in front of a judge with someone who can't pay, saying, I can't afford to pay. And it can become quite difficult to produce evidence that they really cannot pay. Like, you've got to prove that they've got an expensive car that's sat in the drive, or, it's difficult, or that it's difficult evidentially to prove that they can't pay the full 10,000. So what judges will often lean towards is a repayment plan, an affordable repayment plan, £500 a month for 2 years, or £1,000 over 10 months. That's what often happens, is you end up in front of the county court judge. This is before, you've exhausted all options, and then you've got to look at enforcement proceedings, which, as I say, we don't have time to go into now. I would need to refresh my memory as well. I think I need to watch my own video to give you proper comprehensive advice on that. I suggest you watch the video, read the book, and then come back to us when you've got further queries.
As to the book, the enforcement bit is in chapter 5. If you can't afford the full book, which is around £30, available on Lulu, it's on our website. It's at the end of the free chapter, available at book.courtwingman.com. But on top of that, if you can't afford the full book, you can go onto Amazon and find chapter 5, which is, I think, book 6 in our book series, and that will give you the specific information on evidence and trial, which includes enforcement options. So you get to go for that. And another question is, I'm having my property repossessed. Is there a way to delay it, as it is on the bridging loan that has ended based on COVID-19? I had issues finding other funding / a buyer.
Yeah, this is, I've been instructed by a couple of defendants over the years who just basically want me to put a spanner in the works of a claimant who's owed a large amount of money, like someone's defaulted on a mortgage. The answer is yes. There are, keep it confidential here. There are ways, lawyers can make life difficult. As we were saying in the beginning of the legal surgery, defendants can make life difficult for claimants. It's impossible to say, so you can kind of use the system against the claimant. You can offer repayment plans, you can offer reduced amounts, you can offer, well, I can't afford it, but here's a holiday. Because what you need to realize is the claimant, will have to spend money on lawyers to get judgment, and to enforce judgment, and then to get an order for sale or possession, and they have to comply to the letter with the requirements in relation to these types of cases, because the courts don't like it if someone's home is at risk, that you've got to cross the T's and dot the I's. In fact, we can think of a case just from 2 years ago where we defended a businessman against another businessman to whom he owed large amounts of money, but he brought, and it was secured on his property, but this person brought the claim wrong, and I'm afraid we just gave him the runaround. We actually got we got costs off of them. The guy was owed the money and had and wanted to charge. So he had the charge on the property. He wanted to enforce the charge and possess or get an order for sale. Ended up spending a large amount of money because his lawyers had brought the claim incorrectly, and postponing the whole issue for like 18 months. So there are ways of that. Don't be too frightened, particularly if you've got a genuine problem.
Well, thank you for that. Hopefully you'll find it useful, Anthony. Another question is, can I show videos in court as evidence, such as a broken running drain?
You can always show videos. There's no evidential rule that says you can't. But as a general point, but I hardly ever, if ever, have come across them being used. I had a client who used our support service a few months ago. He wanted to take his laptop to court, and I was like, yeah, okay, fine, bring it to court. But really, the judge is going to want to have seen in advance of the trial a printout of photographs or or descriptions or whatever. He's unlikely going to be that. It's just very difficult to deal with video evidence. I mean, it's hard enough finding a document with the court these days, let alone trying to get a judge to watch a video. And don't forget, you've got to obey all the rules. You've got to send the video to your opponent as evidence. You've then got to include it in a witness statement. You've then got to make sure the judge is actually going to be able to watch it. I mean, judges aren't young, are they? Usually. You're running into all sorts of logistical problems of actually trying to integrate it into a trial. Now, obviously, in bigger, higher value cases, you can make it happen. But I often find that the evidential weight really isn't there. It's the same with people who record telephone conversations and say, can I use it in court? It's often not, it just, speaking from experience, I don't quite know why, but they never seem to go anywhere, and they always make the person who's using them look a little bit kind of dodgy and sly.
Or a bit crazy. Or a
bit crazy. But I mean, if you have got a video that is, because as I say, I did advise this other guy in this case to take his video on his laptop, because he was a designer of a promo for a website, and it was animation, and the defendant was saying it wasn't good quality, and that's why he didn't pay the bill. And someone else who's trying to wriggle out of their debts, and he went all the way to trial on his own. He never needed to use it because the defendant didn't show up, because most defendants haven't got, trying it on. So he never got to show the judge the video. But I told him before the hearing to have photos. Don't rely on video evidence. Yeah, unless it's critical and high value, but we're not talking about that in these legal surgeries. Best to get photos of the drain pipe, in my view, rather than to get too clever with trying to file and serve USB sticks with video evidence on that ultimately no one will have time or the ability to read and watch.
Oh, a USB stick wouldn't fly anyway, because the antivirus and protection barriers installed by...
Well, you've got a lot of...
Yeah, they don't allow that to happen. I mean, maybe best to attach a sharing link if it's really, really, really necessary and be like, access this here. But yeah, like Alex said.
Photos or 6 photos.
Yeah, photos of individual one. And then I also have a video if.
Yeah, exactly.
But hopefully they'll just take that and believe you. And there's another question here, but really it needs an email. So can I go for no win, no fee?
Well, we are running out of time, Ping.
Yeah. Or this one is, can I go on no win, no fee on a travel agent civil matter? And I suppose the answer is email the office with the document.
Yeah, you can do no win, no fee for most things, but the problem is a lawyer might not want to do no win, no fee if it's not a strong case. And if there's not a lot of money if you win, because he's leveraging your winnings in return for working on a conditional free basis. So unless it's a large amount of money, because it could go all the way to trial and it could be a 50 grand legal bill. And that, so if it's on a 25% no win, no fee, you know, it needs to be a £200,000 claim sort of thing in order to, it's a bit of a vague generalization, but you've got to know that there's genuinely good amount of winnings that the lawyer can take a percentage of, and also that your opponent can afford to pay.
Well, that's a good ending to this episode of Lawyer Question and Answer session. We run these sessions every other week, always on a Friday, always at 12 p.m. UK time. If you would like to receive updates about our news videos or about the book or about these specific sessions, do subscribe to our newsletter. All information can be found on courtwingman.com. The book is available on Lulu. I've provided a link in the chat, and you can also buy individual chapters on Amazon if you are short on money. And regarding some of the questions here, they can be answered, and we've got the answers on the channel itself. For example, no win, no fee. There's a specific video on that using a pirate analogy. So do go and watch that if you need to know more. And if you have an inquiry and need more help, then email us at hello@courtwingman.com and we will be able to take it from there. Our legal surgeries are £150 an hour plus VAT, and you would be speaking to a qualified solicitor, i.e. Alex or our colleague Daria. That's it from us today. Enjoy your Fridays, enjoy your weekends, and we'll see you soon. Hit that subscribe button and like this video, as it helps other people to discover this channel and get free help. Thank you, guys.
Thank you very much for hosting, Kinga.
Oh, no problem. The book is also in PDF.
So seamlessly. Sorry? The book is...
Another question, quick one. The book is in PDF, both the full one and the individual chapters on Kindle. The individual ones are just Kindle, whilst the full one is a downloadable PDF. So
I thought you could get paperback, hand hardback, both the individual books and the full book.
Oh yeah. So you can get the full book in as an ebook, which is a downloadable PDF. You can get it as a paperback, and you can get it as this lovely hardback if you don't want it to get damaged, or just simply are a book freak like me and like pretty covers. So yes, and then we've got the individual chapters on Amazon too, if someone's short on money, and they're $7.99 for the Kindle version, but it's not a downloadable PDF.
Oh, I see. Okay.
Yeah. And yes, the email is hello@courtwingman.com. Well, if you hate PDFs, you better get the paperback copy then. They are reduced in price, to be fair.
If you hate PDFs, you shouldn't be going to court on your own, because you've got to learn to turn everything into a PDF.
That is very true.
Yeah.
Well, on that note, we are ending this live stream.
Yeah. PDFs.
Yeah.
Good. Cheers, Kinga. Bye for now.
Bye-bye.